Hi guys, it's Kathy. I hope you're doing well. We made it to Saturday. Yes. I got to work yesterday and it was just me and another server on, and poor thing had broken her foot. Came into the cast. But she had taken a bunch of pain meds and was really, so she was sent home right away. So it was supposed to be just me, which would have been fine, but it got worse. Out of nowhere, I had to train someone yesterday. Oh, it was so the first bus came in, and you know, when the buses come in, you got to run around like a chicken as fast as you can. I had to train someone while doing that. My goodness, but we made it through. We made it through. Now, today, it's a full staff. Like there's probably gonna be 5 servers on. I liked it better when it was just me. I got out 30 minutes earlier than I did when I'm with other servers. But we're going to go to 2 judges today. Christofino, which we haven't seen in a while, and Cutie Pie. I can't remember his name. You know, Judge Cutie Pie. No idea what his name is. Just Judge Cutie Pie. So let's start with Christofino. This is Indiana. Okay, there we go. Twitch wasn't working, and now all of a sudden it is. And now it's not. Hold on. There we go. We're good.
Ms. Clays, are you aware of any amendments that need to be made to the precinct's investigation report?
I'm not, thank you.
Your Honor, I am looking at it right now.
So, Mr. Bardot, I want to ask you some questions, okay? I show in here that you have 4 prior misdemeanor convictions and 3 prior felony convictions. Is that correct?
Yes, Your Honor.
I show that you failed to appear 7 times, violated probation at least 2 times, and community corrections at least 2 times. Is that correct?
Yes, Your Honor.
When they did your IRAS score, you came out as a high risk to reoffend. I'm not asking whether you agree with that or not, because you can argue that later. I'm just asking if that's what probation determined.
I guess so.
Okay. And I want to be clear, counsel, so you know what I'm doing. I'm looking at aggravators and mitigators. I'm going to hear mitigators. I don't believe there's any other part of that pre-sentence investigation report with the exception of prior resources utilized to try and rehabilitate Mr. Bardot that the court would consider.
They all probably thought I'd oversleep a couple hours.
When you get through it, Mr. Johnson, let me know.
Okay, Your Honor, I'm prepared.
If you know who those people are in the picture behind him, let me know. I don't.
Did you see anything that needed to be amended?
I did not say anything that.
Pre-sentence investigation report is approved as filed. arguments,
Hold
Mr.
on, hold
Johnson.
on. Whoa, whoa, whoa,
Thank
whoa,
you, Your
whoa,
Honor.
whoa.
In reviewing the
Oh
PSI,
my
I will note
gosh.
that Mr. Pardo.
That is a new courtroom, right? I'm not crazy. That's a new courtroom. So he moved too. This is the first time I'm seeing him in the new courtroom. Remember we saw, the courtroom from hell is gone, and she was in her new courtroom. Judge Christofito's in his new courtroom now too. So, two things used to happen in his courtroom that we don't ever get to see anymore. Thing number one is that there was always buses and police and ambulances and garbage trucks driving outside of his courtroom. And we would just hear all the traffic all the time. And then the second thing was there was this little gate that people had to pass to cross the bar. And I think there was a step there. And people would either get hit by the door or trip on the step. And now we don't have any of those problems anymore. That's pretty cool.
Does show remorse for his conduct. He's taking responsibility for his part in these thefts. It seems to be that the thing that was going on here is scrapping behavior, and that's what Mr. Pardo had been doing. He was also giving some other people a ride. The victim here was the AMC movie theater that was vacant at that time and vandalized by many scrappers, and has since been torn down. Your Honor, he's served, I think it's 304 or 234 actual days in custody. He's according to probation, they are suggesting an executed sentence followed by probation. I think that 234 days of actual time is quite a bit of an executed sentence. So what we're asking the court to do is to give him the remainder of any time that the court wishes to give him on probation to start out with. Thank you.
Thank you, Mr. Johnson. Ms. Clay?
Thank you, Your Honor. Mr. Pardo certainly has received a lengthy or I guess substantive benefit from the plea agreement. The only reason that he was offered the level 6 was because based upon the timing of the initiation of the investigation, there was some question as to whether or not he himself had broke and entered the AMC movie theater or whether he was assisting another individual who had done that with taking the materials out. Mr. Pardo is listed as risk to reoffend. He has a somewhat lengthy criminal history. I'm gonna guess probably most of his criminal activity, other than driving offenses, is based upon his substance abuse use. I have a very hard time believing that even based upon his own statements in the pre-sentence investigation about dumpster diving every day, that Mr. Pardo has not used methamphetamine since 2015 and 2016. I think that he has probably a lot of addictions issues.
No. Okay, no. You can't just say that because you think he might have addiction issues since 2015. You have to prove that. You can't just... What's going on?
That need to be addressed, but I'm not sure if there's enough time left on his sentence for any of those to be addressed and for him to be rehabilitated. Based upon all of the aggravating factors, Your Honor, the state is asking for a 2.5-year sentence, all to be served on community corrections with no period of probation to follow. Thank you.
Thank you, Ms. Clay. Up to you, Mr. Pardo. What do you want to tell me before you get sentenced?
I'm sorry for what I did, and I just want to get it over with so I can be with my family again.
Okay. Cause coming on for sentencing, defendant appears in person for the Elkhart County Correctional Facility via WebEx and by Attorney Matthew Johnson for the Attorney of Record, Chief Deputy Public Defender Bridget Faulkner, State of Indiana Court by Deputy Prosecutors Don Pitzer and Kathleen Clays. The pre-sentence investigation report is approved as filed. Court hears arguments from counsel. Court hears a statement from the defendant. Defendant Jason M. Bardot is now found to have the following mitigating factors. 1, defendant accepted responsibility for his crime. 2, the statements the defendant made here in court today are all mitigating. 3, his attorney's statements made in court today are all mitigating. Defendant Bardot is found to have the following aggravating factors. His prior criminal history consisting of 4 misdemeanor convictions and 3 felony convictions. He violated probation 2 times in community corrections, at least 2 times, and failed to appear at least 7 times, which shows a disregard for the law and society. As a supplemental factor, the defendant's IRAS score is a high-risk category to reoffend. It's clear to the court other forms of sanctions proved to be unsuccessful in keeping the defendant from engaging in criminal activity. It's also clear that he's not taking advantage of programming and alternative sanctions offered to him in the past, like short periods of incarceration, suspended sentences, probation, restitution, addictions treatment, work release, prison, good behavior, community service, restitution, moral recognition therapy, court costs, and fines. The court finds that the aggravators taken individually or as a whole outweighing mitigating factors and that an enhanced sentence is appropriate. Jason M. Bardot, I sentence you on theft, a lesser included offense as a level 6 felony, to the 1-year advisory sentence, which the court enhances by 1.5 years for aggravating circumstances, for a total of 2.5 years to the Indiana Department of Correction. Pursuant to the plea bargain agreement, you are alternatively placed at Elkhart County Community Corrections at a level to be determined by Elkhart County Community Corrections. Elkhart County Community Corrections to transport the defendant from Elkhart County Correctional Facility to Elkhart County Community Corrections. Defendant ordered to pay court costs. Defendant fined $1,000. That fine is suspended. Defendant ordered to pay a $200 public defender fee. Court finds the defendant will not be indigent because he'll be employed when he's on Elkhart County Community Corrections. Court admonishes the defendant that the law does not allow him. This court will not incarcerate the defendant for failure to pay fines and costs if the defendant is indigent. Court orders the defendant to provide a DNA sample of
Maria, thank you so much for the cheers.
his cost pursuant to statute if he's not already done so. Court awards the defendant credit for having served 234 actual days in custody plus good time credit per statute. Bond, if any, is released. The appointment of the public defender's office is withdrawn. The order of commitment is entered and the defendant is remanded to the custody of the sheriff to carry out the executed sentence. It is so ordered. Good luck to you, Mr. Bardot.
Thank you.
Yikes.
Jill, you can get somebody in, but we're gonna do the interpreter case now, which is out of custody.
Yes, sir.
So, you can get Clayton Reed in, but Christian Parada Quintanilla.
As he said for today.
He's up.
Do you think he got to pick the picture? Or that's just for in the new courthouse?
Twenty CO1, 2301 CM94, 20 CO1, 2301 F512, State of Indiana versus Christian Parada Quintanilla. Mr. Aguilar, raise your right hand, please. Do you swear and affirm under the pains and penalties of perjury that you will justly, truly, and impartially interpret to Christian A. Parada Quintanilla the oath about to be administered to him and the questions which may be asked him and the answers that he shall give to such questions relative to the cause now under consideration before this court?
I do.
State your name for the record.
Adrian Aguilar?
Are you a certified interpreter?
Yes.
Is your native language Spanish and did you learn English?
Yes.
Have you translated in this court and other courts in Elkhart County way over 1,000 times?
Yes.
Will you notify the court if you have any problem in translating the proceedings?
Yes.
You agree to be bound by and will you follow the Indiana Supreme Court Interpreter Code of Conduct and Procedure in effect at this time?
Yes.
I now order you to interpret the proceedings word for word. Will you do so?
Gosh, leave the interpreter alone. No one else grills the interpreter like this, Judge.
Yes.
Mr. Parada Quintanilla, please
Parada
raise your
Quintanilla,
right
por favor,
hand.
levante su mano derecha.
Do you swear or affirm under the
Que si
pains
usted
of
jura o
perjury?
afirma bajo las penas y
The
penalidades del
testimony you're about to give will
que
be
el
the
testimonio
truth.
que usted está a punto de dar será la verdad? Sí. Yes.
State your name.
Declare su nombre.
Cristian Alexi Parada Quintanilla.
Cristian Alexi Parada Quintanilla.
Show the defendant
Señor,
appears
la
in
persona
person
aparece en persona.
by his attorney
Por
Matthew
su abogado
Johnson,
Matthew Johnson.
State of Indiana in court by Deputy Prosecuting Attorney Don Pitzer, and Kathleen Clays. Certified interpreter Adrian Aguilar appears and translates the proceedings for the benefit of the court and the defendant. You appeared today for sentencing having pled guilty to burglary, a level 5 felony. Is that your understanding?
¿Eso es lo que usted tiene entendido?
Sí.
Yes.
Because this is a level 5
Este es
felony,
un
you must
delito
do
mayor nivel 5,
75% of your time.
75% de su tiempo.
In other words, you have to
Palabras,
serve
usted
3
tiene que
days
servir
in
3
jail
días en la
to
cárcel
get 1 day of
para
good time
recibir
credit.
un día de crédito de buen comportamiento.
Do you understand that?
¿Entiende usted eso?
Sí.
Yes.
Do you have any questions of the court regarding
¿Tiene usted alguna
credit time?
pregunta para el juez con respecto al tiempo de crédito?
No.
No.
Do you understand that you waived your right to
Usted que
appeal
usted
your
está renunciando a su
conviction
derecho de apelar
and
su
sentence
convicción
in
y
this
condena
case?
en este caso.
Sí.
Yes.
Did you have a chance to
¿Tuvo
review
la
the
oportunidad
pre-sentence
de repasar el
investigation
informe
report?
precondenatorio?
Sí.
Yes.
Did you review it with your attorney?
¿Lo repasó con su abogado?
Sí.
Yes.
Let's be clear, did somebody go over it with you in Spanish?
Vamos a ser claros que si alguien lo repasó con usted en el idioma español.
Sí.
Yes.
Mr. Johnson, any
Señor
corrections
Johnson,
to
¿alguna
the pre-sentence
corrección al
investigation
informe
report?
precondenatorio?
No corrections.
Ninguna corrección.
Ms. Clays, any question or any amendments?
Señora Claes, ¿alguna enmienda? No. No.
Pre-sentence investigation report is approved
El informe
as filed.
precondenatorio es aprobado como levantado.
Mr. Johnson, arguments.
Señor Johnson, argumentos.
Thank you, Your Honor. This is
Gracias,
stipulated
señores.
plea
Este es un
agreement for the
convenio
court's
declaratorio
consideration.
estipulado para la consideración
We're
del
asking
juez.
you to
Nosotros
sentence
estamos
according
pidiendo que se
to
condene
the plea agreement.
conforme al convenio declaratorio.
I think that it's important for the court to know, and I think the court has a good idea, kind of what's been going on throughout the pendency of this case. Mr. Parada Quintanilla has made amazing strides since the very first time that I met with him with Mr. Aguilar out at the jail in regards to his mental health. This started as what could have been a case where he was potentially even incompetent. Luckily, he was able to eventually bond out of jail, and he has been restored. I'm very confident to full competency with the help of Oaklawn. He's been working very closely with Oaklawn for the entire time that he's been out of custody. He's
Whew, poor interpreter. Thank you so much, Jude. Thank you. This guy's doing well, so nothing bad will happen.
been providing us with updates and is doing very well. He's working and is living a good and stable life. I think that he's going to be able to get through this through any probation that the court gives him. He is currently still going to Oaklawn. He does have some immigration issues. That being said, this plea has been in a consultation with Felipe Marino. So he's been well advised at everything that's going on. He's a legal resident, so he's able to work legally, and we don't foresee any issues on that part. With that being said, we're asking you to sentence him according to the plea agreement. He has quite a bit of credit time from the time that
Well, that's not good.
Por
the time
lo
that he was
declaratorio
in,
tiene mucho
and,
crédito, una buena
um,
cantidad de crédito de todo
have
el
him
tiempo
be
que
on
pasa en el
probation.
custodia.
Cristofino, sir. What are you doing? So, I got a sticker for once, and no, it's not a sticker, it's just a piece of paper with the DoorDash driver hopes something good happens for me today. Right? Well, it's not my damn stream. What the heck is going on with Cristofino? This circle is that it was not. That happened when it was recording. So I don't know if there were storms somewhere or something.
Aprobado como
I'm gonna
levantados.
fast forward it.
Here's arguments from counsel.
Escucha los argumentos
Escucha.
de los abogados.
Mentos.
Yes.
I'm just gonna get fast forwarded a bit to the next case. Oh, he left. Chair watch. Chair watch. Oh, it's so unforgiving. This stupid fast forward button. It's just a slider. I'm gonna go to. No, I can't hear anything either. Where did Cristofino go?
He gets sentenced today.
We speak. He's
From this Monday, October 6th, to January 5, 2026 at 8:30 o'clock a.m. Is that what you want me to do?
8:30 o'clock
Yes, sir.
a.m.
Are you therefore acknowledging on the record that your new jury trial is January 5, 2026 at 8:30 o'clock
Yes,
a.m.?
sir. Yes, sir.
Maybe I'm number 2.
You understand if you don't show up to that jury trial,
You
the
don't
court is
know.
going to hold the jury trial without you.
Yes, sir, I do.
So if you want to tell your side of the story, present witnesses and evidence, you need to be in court for your jury trial January 5, 2026 at 8:30 a.m. Do you understand that?
Yes, sir.
Trial status conference is going to be December 11, 2025 at 8:30 o'clock a.m. Mr. Bank, you need any other dates right now? You can get them later if you do.
I don't, Your Honor, would it be possible to do the 18th? I'm hoping to get some CLEs done before.
Trial status conference?
Yes,
Go back. Trial status conference is going to be December 18, 2025 at 8:30 o'clock a.m. Mr. Newcomb, you're going to see me in court next time, December 18, okay?
Yes, sir.
Bonds coming on for trial status conference and bondsman to produce. Defendant appears in person via WebEx and by his attorney, Michael Bannick, State of Indiana, in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen
Guys.
Clays. On motion of defendant, jury trial continued to
You can
January
see who
5,
number 2 is.
2026.
All right. Number 2 is our dearest Terry. And I know number 2 is Terry because Terry with an I. Terry Ham. I know it is because if you go to chat and you click top fans up at the top right, it'll show you everybody. Jude, you're number 1. Then it's Terry. Then it's Maria. Then it's Monica. Then it's Kelly. But that's because Terry, Maria, Monica, and Kelly all have the exact same amount of points. So they're all number 2, really. Hi, Terry. I was just talking about you.
At 8:30 o'clock a.m. Defendant acknowledges jury trial setting on the record
Hey,
for purposes
Carlos.
of criminal reform. All time is attributed to the defendant. Trial status conference scheduled for December 18, 2025 at 8:30 o'clock a.m. It is so ordered. Thanks, Mr. Newcomb. You can hang up. You're all done.
Thank you.
Stay in touch with Mr. Bannick.
Yes, sir, I will. Thank you, Mr. Bannick.
yep,
Thank you, Mr. Bannick. You got anything else?
that's it.
Thank you, Mr. Bannick. Mr. Johnson, you ready?
I'm ready.
Lonnie,
Jude, it'd be hard for someone to mess with this stream because Chat would murder them. Chat would murderize them. And that's basically really all they could do is mess with chat. Yeah, mess with the video. The video is already messed.
Collins, Jill, you got Lonnie Collins there?
Yes, sir.
There we go. Hang on, Mr. Collins, let me pull your case out.
Yeah, give me till next week.
20C0125.
Now I want someone to come in and mess with chat.
F5107, State of Indiana versus Lonnie N. Collins. Mr. Collins, raise your right hand. Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Yes, sir.
State your name.
Lonnie Neal Collins.
Thank you. Show the defendant appears in person from the Elkhart County Correctional Facility, Texas, by his attorney Matthew Johnson, State of Indiana, in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. This matter is on for trial status conference, but it's for the October 20 trial date, Mr. Johnson.
Thank you, Your Honor. Today, we're asking to continue the trial date.
Any objection?
No.
Hey, Mr. Collins, your attorney wants to continue your jury trial from October 20, 2025 to January 5, 2026 at 8 p.m. Is that what you want the court to do?
What's that? I didn't hear.
Mr. Collins, your attorney wants to continue your jury trial
Right.
from October 20, 2025 to January 5, 2026 at 8:30 a.m. Is that what you want the court to do?
Yes, sir.
Are you
Yes.
therefore acknowledging on the record that your new jury trial setting is January 5, 2026 at 8:00 a.m.?
Okay.
That okay? Are you acknowledging it on the record? Yes or no?
Yes.
Do you understand that if you don't show up for the jury trial, the court will hold the jury trial without you?
Yes, I would like the bank president and the bank teller.
Mr. Collins?
Yes.
I'll take care, we'll take care of everything. This isn't a time to talk about anything.
Okay.
Your trial status conference is gonna be December 11, 2025 at 8:30 a.m. Cause coming on.
Sir, what did you do at the bank? You think you freaked out at the bank? December is so far to answer my question.
On for trial status conference. Defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney Matthew Johnson, State of Indiana, in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays on motion of defendant. Jury trial continued from October 20, 2025 to January 5, 2026 at 8:30 a.m. Defendant acknowledges jury trial setting on the record for purposes of criminal reform, all time attributed to the defendant. Trial status conference scheduled for December 11, 2025 at 8:30 a.m. It is so ordered. Thanks, Mr. Collins. You're all done.
Thank you.
Jeffrey Estep.
Yes, Your Honor.
Twenty CO1 2411 F350, 20 CO1 2409 F6 1098, State of Indiana versus Jeffrey M. Estep. Mr. Estep, raise your right hand. Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Yes, I do, Your Honor.
State your name for the record.
Jeffrey Estep.
Put your hand down, please. Defendant appears in person for the Elkhart County Correctional Facility via WebEx and by attorney Matthew Johnson for the attorney of record, Mackenzie Bowling, State of Indiana, in court by Deputy Prosecuting Attorneys Don Pitzer, Kathleen Clays. Sentencing, what do you want to do?
Your Honor, Ms. Bowling has asked me to continue the sentencing for 1 week.
Mr. Estep, you have a right to be sentenced within 30 days. That's why I said it today. Ms. Bowling couldn't be here today. Is it okay with you? Will you waive your right to be sentenced within 30 days? Can I continue your sentencing for 1 week and you'll come back next Thursday, October 9.
I can't get sentenced today.
I think it's gonna be really, really hard to do that. Because,
I mean,
for
I'm-
example, have you reviewed the pre-sentence investigation report?
Yes,
Did you review it with Ms. Bowling?
yes, I did.
If you want to go forward, I do have some notes, but it,
Hang on a minute,
Please.
let me pull it up and see what it is. Just hang on. I want to be clear, Mr. Eastep, you don't want to waive your right to be sentenced within 30 days, correct?
No, I want to be sentenced today if possible, Your Honor.
The part that's left up to me is prison time. It's all got to be suspended.
it's, okay,
That's the reason why I think I understand exactly what Mr. Eastep is thinking.
okay.
Okay, so Mr. Eastep, you understand you're gonna be sentenced on attempted robbery. And I think it says armed robbery, a level 3 felony. Do you understand that?
Yes, I do, Your Honor.
You have to do 75% of the time. That means you have to do 3 days in jail to get 1 day of good time credit. Do you understand that?
Yes, I do, Your Honor.
Do you understand that you waive your right to appeal your sentence and conviction in this case?
Yes, I do, Your Honor.
That was pursuant to paragraph 20 of your plea bargain agreement. Do you understand that?
Yes, I do, Your Honor.
Now, because there is one district out there that says you may have that you have a right to appeal discretionary sentences, I'm going to give you what is commonly referred to as your criminal rule 11 rights, in case you have a right to appeal the discretionary sentence in this case. In order to do an appeal, you must file either a notice of appeal or a motion to correct error within 30 days of the date of sentencing. That's today. If you elect to file a motion to correct error, you must file your notice of appeal within 30 days of an adverse ruling on that motion. Failure to comply with these will result in the forfeiture of your right to appeal. You have a right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you're unable to afford an attorney, I'm obligated to appoint one to represent you at no cost to you. Do you understand your criminal rule 11 rights?
Yes, I do, Your Honor.
Do you understand that under the law, I am of the opinion that you have waived your right to appeal your conviction or sentence in this case? Do you understand that?
Yes, I do, Your Honor.
And I specifically find that you so have waived your right to appeal. Now, you told me you reviewed your pre-sentence investigation report and you reviewed it with Ms. Bowling, correct?
Yes, I did, Your Honor.
I take it you did not have a chance to review it with Mr. Johnson.
No, I didn't, Your Honor.
Were there any corrections or amendments to the pre-sentence investigation report, Mr. Eastep?
No, Your Honor.
Mr. Johnson, did you see any?
No.
Ms. Clays, did you see any?
No.
Pre-sentence investigation report is approved as filed. Arguments, Mr. Johnson.
Thank you. According to Ms. Bowling, Mr. Eastep has several leads on jobs, and many employable skills. His father owns a
was
tree
right.
service and he's planning to start there. He has an excellent support system, and involved parents. He's married to his wife. He's a skilled laborer and has transportation to and from job interviews and jobs. He's planning on living with his mom off River Bend Circle in Osceola, who has no addiction or criminal history. He's while at the Elkhart County Jail, he's been in the program pod and has completed.
He's not going to live with his wife? I wonder if it was domestic that he's in here for. Which brings me to a question. I think I asked this once before, but I don't know the answer anyway. So normally if you commit a felony, when you get out of jail, you're not allowed to live with someone who has committed a felony. I think while you're on probation, you're not allowed to live with other felons. What if your wife has a felony? If someone who is not in jail for domestic, maybe they're in jail for drugs, or robbing a bank like that other guy, and they get a felony for it. If they get out of jail and they're not allowed to live with felons and their wife is a felon, or their children are felons, let's say they have a 14-year-old who is a felon, are they not allowed to live with them? Because what if they're the guardian? I'm sure they'll make an exception for that, for the kid. But what about the wife? He's going to live with his mom.
The Courage to Change program booklet, and he already has a clean slate appointment scheduled for the 6th of October. And his mom will have the ability to transport him to and from doctors and pharmacies and things of that nature.
Looks so confused up there. You asked for this, remember? There was going to be an attorney to help you with your sentence. And you said, no, dog, just do it right now. Why are you so confused? Pay attention.
That's all.
Please.
Thank you, Your Honor. Mr. Estep has received an extremely favorable plea in a case like this. It is not the state's common practice to put someone who's committed a crime like this simply on probation. So I wanted to make a more thorough record with the court as to the considerations for Mr. Estep. The victim in this case, Your Honor, is an elderly gentleman who has some very serious medical conditions. He has never been involved in anything regarding the criminal justice system, and his medical conditions were greatly exacerbated by even being asked if he would give a deposition in this case. Putting him through the trial process was not something the state thought was in his best interests. I recognize that Mr. Estep has taken responsibility for the crime as charged, which is a level 3 felony. I think that that is important. Unfortunately, for at least, I think, some of Mr. Quall's family members, despite our victim advocates' best efforts, I don't think that they understand the trial process and how a criminal case has to be presented to a jury. And Mr. Quall's testimony at trial was absolutely necessary to be able to prove this case, because he essentially was the only witness to it. And so the state, in lieu of making Mr. Qualls go through that process, chose to hold Mr. Estep accountable for the level 3 felony, but place him directly onto probation. The state is asking for an aggravated sentence in terms of time that Mr. Estep is under the supervision of the state, based upon Mr. Estep's criminal history, which includes several convictions for theft. It appears that Mr. Estep likes to go around stealing things from people that don't belong to him. He has a domestic battery back from 2016. There have been criminal mischief charges. I don't think there was a conviction in that case, but there are many, many theft cases. He's listed as a high risk to reoffend, and certainly just the nature and facts of this case are particularly egregious based upon Mr. Quall's age, the fact that he'd never had any contact with Mr. Estep, and based upon the victim impact statements, both from Mr. Qualls himself and from his daughter. This has had a tremendous effect on what are supposed to be the golden years of his life. He has been very traumatized by this. So from the state's perspective, yes, Mr. Estep has received a substantial benefit from this plea, but I can assure Mr. Estep that the minute he puts 1 foot out of line on probation, the state is going to be asking for him to be returned to the Department of Correction, no questions asked. So based upon all those factors, Your Honor, the state is asking the court sentence him to an aggravated term of sentencing on probation. I know that the court has accepted the plea and asked that the court simply sentence him according to any other terms in the plea. Thank you.
What about restitution?
Um,
Restitution in both cases, I don't have amounts on anything.
Judge, I don't believe that I have a restitution amount either, so I'd ask that the court keep that issue open through the course of probation, and I can provide documentation if I receive it, in either case.
Thank you, Ms. Clays. Your turn, Mr. Eastep. What do you want to tell me before you get sentenced?
I want to say that what I did was a foolish act, and there's no excuse for it, Your Honor, and for that I am very sorry. I can't say that I'm sorry enough. I do want to say going into this probation this time that I do have a great support system and that I do have stuff lined up and I do have a plan. Like I said, I got my wife that's behind me, my mom, my dad, and I also mending relationships with my children. I already got a doctor's appointment to go get on my medicine, so I'm not out there trying to get on street drugs or anything. My dad does have some work for me, so I can start working right away. But until I find full-time employment. And then I also got my education, my GED, and I want to further my education. I just feel like that this time I can be very successful, and that's about it, Your Honor.
I'm still stuck on the part where he's not going back home. He's going to his mom's house. It wasn't domestic violence. He beat up an old man who had serious medical conditions. So why isn't he going home afterwards? It doesn't sound like he has a job, because he's going to look for employment. But why is he going to his mom's house? Why doesn't he go home? Is it because he's a felon and she has a felony? That could be it, right? Right?
Well, for your sake, I hope you are. Because I'm going to tell you right now, I think this, I heard everything Ms. Clay says. I think this is an outright gift. I've already accepted it. I'm bound by it. You listen up, young man, because you're going to hear me talk about 12 years suspended on probation. And I can assure you, you violate probation, you're going to the Indiana Department of Correction. So you mind your P's and Q's while you're on probation.
Yes, sir.
Robbery is a very, very personal act. And
he beat him up and then robbed from him. When this judge says, I'm going to put you in the Department of Corrections, this judge means I'm going to put you in the Department of Corrections. There's no mitigators. There's no aggravators. If he messes up, this judge is going to sentence him. There's no way to talk you. There's no excuses. He'll accept. Because what this judge feels and how he acts is, this is the law, okay? You broke this law. Now, every single other person who comes into my courtroom that breaks this law gets this sentence. Therefore, you are getting this sentence. No, you don't have to give me excuses, because it doesn't matter. You're not special. This is the law. You broke this law. This is your sentence. And he's a stickler. Like, the excuses people tell him, and he's like, hey, if I was out on the street with you, that would make me feel bad. But we're not out on the street together. We're in a courtroom, and I'm a judge, and this is my job, and this is what you did, and you're going to jail. He did say that. He said, I believe they said that their child was either dying or had passed away, and he's like, yeah, if I was on the street, that would make me feel bad.
the victim in this case was traumatized beyond what is necessary for fear. And you're going to hear me talk about that, but way beyond what's necessary for fear for an attempted robbery. Mark this. Cost coming on for sentencing. Defendant appears in person. from the Elkhart County Correctional Facility via WebEx and by Attorney Matthew Johnson for the Attorney of Record Mackenzie Bowling, State of Indiana in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. The pre-sentence investigation report is approved as filed. Court hears arguments from counsel. Court hears a statement from the defendant. Court finds mitigators to be as follows. The defendant accepted responsibility for his criminal conduct. The defendant's statements in court today, the defendant's attorney's statements in court today, and the defendant's mental health issues. Aggravating factors are as follows. Defendant's prior criminal history consisting of 5 felony convictions and 6 misdemeanor convictions. The fact that the defendant was on parole when he committed the attempted robbery. A pending level 6 case is being dismissed pursuant to the plea bargaining agreement. The defendant had conduct violations while incarcerated at the Elkhart County Correctional Facility. The defendant violated probation or community corrections 7 times, failed to appear 6 times. All of this shows a disregard for the law and society. The defendant traumatized the victim greater than necessary for the element of fear in attempted robbery. Defendant followed the victim after the attempted robbery. Defendant fled the scene to avoid arrest. As a further aggravating factor, the court finds as a supplemental factor the defendant's IRASC score of high risk to reoffend. Other forms of sanctions proved to be unsuccessful in keeping the defendant from engaging in criminal activity. The defendant has not taken advantage of programming and alternative sanctions offered to him in the past. I'm talking about juvenile referrals, suspended sentences, short periods of incarceration, probation, Salvation Army Rehabilitation Center, community service, theft accountability program, victim offender reconciliation program, restitution, Michigan Community Corrections, anger management, good behavior work release, Elkhart County Community Corrections, prison at the Indiana Department of Correction, domestic violence programming, no contact orders, community transition program, court costs and fines. The court finds the aggravators taken individually or as a whole outweighing mitigating factors, and that an enhanced sentence is appropriate. The defendant is sentenced on attempted armed robbery, a level 3 felony, to the advisory sentence of 9 years, which the court enhances by 3 years for aggravating circumstances for a total of 12 years at the Indiana Department of Correction. Pursuant to the plea bargaining agreement, all 12 years are suspended, and the defendant is placed on 12 years of probation at a level to be determined by probation. The defendant is ordered to report to probation within 3 business days of his release from custody. Mr. Estep, do you understand the terms of probation?
Yes, sir, I do.
For the record, court finds the defendant understands the terms of probation. Defendant ordered to pay court costs. Defendant finds $7,000. The court suspends that fine. Defendant ordered to pay a $200 public defender fee to the clerk of the court. Defendant ordered to pay restitution to the victims in both cases in an amount to be determined by the court upon evidence presented to the court. Court finds the defendant will not be indigent because he'll be employed while he's on probation. Court advises the defendant that the law does not allow and the court will not incarcerate the defendant for failure to pay fines and costs if the defendant is indigent. Court orders the defendant to provide a DNA sample at his cost pursuant to statute if he's not already done so. Court orders the defendant to have a mental health evaluation and follow-up treatment. Do you want to do that at Oaklawn or where do you want to do that?
Oaklawn's fine.
At Oaklawn? Defendant given credit for having served 40 days in actual custody plus good time credit per statute. Case 20-C01-2409-F6 1098 is dismissed pursuant to plea bargaining agreement. The sentence in this case is consecutive to 20-D02-1902 F5-39. Bond is released. Appointment of the public defender's office is withdrawn. The order of suspended commitment is entered, and the sheriff is ordered to release the defendant upon receipt of this order. It is so ordered.
I missed how many years he will get in the Department of Corrections if he messes up. When he messes up.
Good luck to you, Mr. Estep.
Thank you.
Mayweather's, hang on a minute. Let me pull your case up. There we go.
Oh, he's gonna do that time. He's gonna do it. I was getting batteries for my alarm clock sent.
20 CO1 2502,
That's why I missed it.
F5 43, 20 CO1 2504, CM 728, State of Indiana. I am unique. I, Mayweathers. Ms. Mayweathers, raise your right hand. Do you swear or affirm under the pains and pains of perjury that the testimony you're about to give will be the truth?
Yes, sir.
State your name for the record.
My best friend in the whole wide world is a dog. She's very, 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 very awesome. Amazing. I love my cats. I do. But they're little assholes. My dog is... You don't even understand. My dog is... Okay. The books, the Twilight books. You remember the Twilight movies and the Twilight books? One of the reasons why they were so popular, even though people don't realize it, the women reading it didn't realize it, was Edward never broke character. I'm just talking about the books. The movies, the whole time since Edward saw Bella, he never broke character one time. Every single thing in his world put her first. Everything. Since he met her. Okay? He didn't turn into a jerk at some point. He didn't lie to her. He didn't... No matter what happened, no matter where they were, life-threatening or not, the Volturi were going to kill them. Edward put Bella first. Didn't matter what the consequences were. That's how my dog is. My dog loves me so much that I am first. I'm just first. Anybody else can do whatever they want, but I am first for my dog. And I love my dog so much. We don't hear about my dog so much because, you want to know why? Because when I'm streaming, she knows that I'm working, and she's right there behind me. I can hear her. She's just there chilling, waiting. Now, if the stream goes too long, she will come and get me. But I could just say, no, not right now. And she'll just go back and wait. That's my dog. My dog is the best. The best. The cats are little assholes. They don't care about me at all. Not even a little bit. If I was hanging off a cliff and all they had to do was push the rope that much, they would never in a million years save my life. However, if you know what they would do? They would push the rope, but they would push it off the cliff the whole way so I couldn't get it. Because they would push everything off the cliff. I don't even know how we're all standing right now. Alright, back to her. We're swearing her in. What about those cats with no fur? You can get one of those.
I'm Unique Mayweathers.
Thank you. So the defendant appears in person with the Elkhart County Correctional Facility via WebEx and by attorney Matthew Johnson, the attorney of record Mackenzie Bowling, State of Indiana, in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. This matter comes on for trial status conference. Mr. Johnson.
Thank you, Your Honor. Seeing the notes from Ms. Bowling, we're asking to continue the trial date.
The objection from the state?
No.
Ms. Mayweathers, your attorney wants to continue your jury trial
Okay.
from October 20, 2025 to January 5, 2026.
I don't know what they're complaining about, Kelly, because I know that they have pets in prison. I know. I saw Orange is the New Black. They train cockroaches. They're their little pets. They train cockroaches to carry cigarettes back and forth. They have pets.
At 8:30 a.m., is that what you want the court to do?
Yes, Your Honor.
Are you therefore acknowledging on the record that your new jury trial setting is January 5, 2026 at 8:30 a.m.?
Yes, Your Honor.
Understand if you don't show up for that jury trial, the court will hold the jury trial without you.
Yes, Your Honor.
So if you wanna tell your side of the story, you wanna call witnesses, you wanna present evidence, you need to be in court for your jury trial on January 5, 2026 at 8:30 a.m. Do you understand that?
Yes, I do.
Your trial status conference will be December 11, 2025 at 8:30 a.m. Cause coming on for trial status conference. Defendant appears in person, Elkhart County Correctional Facility via WebEx and by Attorney Matthew Johnson for the Attorney of Record Mackenzie Bowling. State of Indiana in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. On motion of defendant, jury trial continued from October 20, 2025 to January 5, 2026 at 8:30 a.m. Defendant acknowledges jury trial setting on the record for purposes of criminal rule 4, all time attributed to the defendant. Trial status conference scheduled for December 11, 2025 at 8:30 a.m. It is so ordered. I'm gonna see you back here December 11, okay?
Your Honor.
All right, thank you.
Hang on a minute.
Could we get a further proceedings date in, I guess, beginning of November?
November 13.
Yes.
Court sets this matter for further proceedings. November 13, 2025 at 8:30 a.m. It is so ordered. I'm gonna see you back here now, November 13, Ms. Mayweather's okay?
Okay, thank you.
Thank you.
If I was a
Mr.
prisoner and the prison offered me a cat as a privilege, as a comfort animal, there's absolutely no way I would say yes to that. There's just, because they can take that cat away from you so fast. If you step out of line in prison, that's the first thing they're coming for. They're taking your cat. Could you imagine that? Could you imagine them just taking your cat away? And there's nothing you can do about it? Maybe you see the cat in someone else's cell 2 weeks later. No. I would not want I don't want anybody in control of what makes me happy like that. That would be terrible.
Bell, you there?
Yes, sir.
Great, hang on a minute. Twenty C01 0506 FA 103, State of Indiana versus Johnny J. Estelle. Mr. Estelle, raise your right hand. You swear or affirm under the pains of perjury that the testimony you're about to give will be the truth?
Yes, sir.
State your name.
Johnny J. Estelle.
Thank you. You can put your hand down. Show the defendant appear in person from the Elkhart County Correctional Facility via WebEx and by Attorney Matthew Johnson for the Attorney of Record Mackenzie Bowling. State of Indiana Court Prosecuting Attorney Don Pitzer. Violation hearing. Go ahead, Mr. Johnson.
Thank you. I have notes here, essentially for sentencing. Has Mr. Estelle admitted his violation?
So. Make positive here, though. I take that back. He admitted his violation back on September 4, 2025, committed a crime, and it was reset to the day near Judge Bowers. And I'm not sure why that was, but it was. That's what it was. He's already admitted.
Okay.
Correct, Mr. Estelle, you've already admitted that you violated probation, correct?
Yes, sir.
Yeah, and we've got a MCC report and an ECC report.
Right. Is there also a credit time in there?
Yep, yes. Starting to talk like my visitors to court, sorry, yes. That was done July 16, 2025, so he's got a lot more credit time.
Right.
Than what that should.
And Mackenzie has it updated some of the numbers.
She fancies herself as a mathematician, did you know that?
It's a welcome thing. from our side.
No, I understand that. I'm gonna go forward with disposition.
Yes.
Mr. Estelle, okay with you? Ms. Bowling couldn't be here today. Okay if we go forward with disposition?
Yes, sir.
Okay. Arguments.
Thank you, Your Honor. Ms. Bowling would like to request for the violation that that he have credit for his time served and that he be done that with an unsatisfactory disposition. Mr. Estelle has severe health issues along with a whole lot of his time served. Ms. Bowling's calculation is that he now has served 5,782 days of actual time of his 6,022 actual days after crediting in his educational credit that is in the credit time memo. Mr. Estelle has, as I mentioned, major health issues. He has daily seizures. He's nearly bit off his tongue. He has lung failure, kidney failure, and severe heart problems. He's very concerned about his health while he's in Elkhart County Jail or any kind of community corrections. He'll be needing to get himself to a lot of doctors. So what we're asking for is for the time that he's done to be sufficient for time served and to close the case. Thank you.
Thank you. Mr. Pitzer.
Thank you, Judge. I have no specific recommendation.
Thank you. I'm gonna give you a chance. Mr. Estelle, what do you want to tell me?
That I realize I violated going into Michigan, but my living family members are there, and they are the ones that take care of me, and I didn't expect to be in trouble for being where they already knew where I was. I have a lot of health issues that are not getting any better with me not getting the proper health care that I'm getting. I'm not in any way trying to make it look any less than what it is to your honor, because you were the one that gave the chance to prove that I could be deserving of my chance, but back in society. And I didn't want to disappoint you. I know that this is a situation where it is a disappointing factor for me to be in front of you, the man that gave me a chance, but I in no way thought that being in the accident that I was in would change my life as much as it has. I just don't know what time I do have left, but I would like to spend that with my family members that I do still have.
Okay, Mr. Stowe, let's talk about some things a minute. Are you able to work?
I cannot work. They have just approved my disability, and I have to get to the appointment that I have with the social security place.
Where are you gonna live?
Now, I have to stay with my mother, and that is in Niles, until I can get my payments from my disability started, so I can get my own place.
That sounds rough, guys. He has to. You don't get a lot for disability.
Are you gonna be able to afford to be on probation?
This time, I don't have an income until I can get to the last meeting to get it finalized with my social security.
Can you get your hands on $125 to get your probation transferred to Michigan through the Interstate Compact Agreement Act?
I will do my best to get it paid.
This guy doesn't know. Oh, I'm so scared for him. This guy doesn't understand. He said something that stopped the judge. That's not normal for this judge. So the judge is now rethinking something. If he starts talking right now, he's going to ruin it. He needs to shut up. I don't want to press play because I don't want him to say anything else.
Hold on a second.
Normally it's a very bad thing when the judge says, hold on a second, and they dig deeper. This time I think it's a good thing. This time I think he stopped the judge. Good job, sir. I don't know what's going on. I don't know what he's looking at. Oh, he's signing something. Too late now, buddy. He signed something. The defense
Did Ms.
attorney.
Bowen
Oh, it's
calculate
over.
what, without the credit time, what it was, without the educational credit time, what it was, the days?
She didn't have that written down,
Hang on a minute.
although the educational credit time was 549 days.
Judge, you're killing me. Come on. You already know. You already wrote it down. Start talking. 549 days of educational credit time. He took some classes and now he got 500 days off of his sentence.
What's coming on for hearing on alleged violation of probation, which the defendant admitted. So, defendant appears in person in the Elkhart County Correctional Facility via WebEx and by attorney Matthew Johnson for the attorney of record Mackenzie Bowling. State of Indiana in court by Deputy Prosecuting Attorney Don Pitzer. Court hears arguments from counsel. Court hears a statement from the defendant. Court now finds that the defendant admitted that he violated probation. Court reimposes the 33-year sentence to the Indiana Department of Correction. Defendant given credit for having served 5,233 days in custody, plus good time credit per statute. Defendant also given credit for having earned 549 educational credit time days when he was incarcerated at the Indiana Department of Correction. Court vacates the remainder of the executed sentence and unsatisfactorily discharges the defendant from probation. Bond, if any, is released. Appointment of the public defender's office is withdrawn. The order of commitment is entered. Defendant remanded to the sheriff to be released upon receipt of this sentencing order. It is so ordered. Good luck, Mr. Estelle. Go back to Niles with your mom and see if you can stay out of trouble.
Can I?
What in God's name just happened? Someone tell me what happened. He was sentenced to 33 years in jail. He's hanging over his head. He was on probation. He violated his probation. He was just discharged from probation. Unsatisfactory. 5,000 days isn't 33 years. I don't understand what just happened. I don't understand. I was listening very intently, but I didn't understand what happened.
I say thank you, Your Honor, because you did get
He's not on probation anymore. He's off probation. So, I don't...
give me a chance.
Good luck. We'll see you.
Thank you.
Jackie Fisher?
No, not Jackie Fisher. Judge Cutie Pie. It's time for Judge Cutie Pie. I can't remember his name. So he is in courtroom Q. This judge that we're about to see is in courtroom Q.
Are cases that needed to be
Hold
added
on.
to that global, and there are also
Hold on. Oh my gosh. We're covering the judge. Contempt of court. Let's I don't remember the last time I played this judge, to be perfectly honest. He does a lot of trials, but he doesn't always do trials, so that's not an excuse. Brett. I need someone with way better eyes to tell me what... Martin. His name is Brett Martin. I'm not going to remember that because his name is Judge Cutie Pie because he's in courtroom Q and he has the little curly hair up top. And when he smiles, he just looks like a 10-year-old. Like, he looks like I don't know. He looks like your son, like a little 10-year-old playing. I don't know what it is about this judge, but he's just a cutie pie. So we're gonna watch him. I don't know what happens here, but hopefully he smiles at least once. Hopefully all these go away so he gets a little bigger.
cases that are no longer open at this point. So we do need some time. As far as the finding of competency, I'm not challenging that either. And I'm not asking for a second opinion. As far as bond goes, I don't see that we were on notice. I'm not prepared to address bond today.
Okay, thank you. Thank you. I did review the evaluation provided by the department. It does appear that the court has sufficient information to make a determination on competency. I will provisionally find that Ms. Smith is competent to proceed. Ms. Barnacle, I'm printing out a copy of the evaluation now. If you do object to the findings or requesting for hearing, I'll order that you make that in writing within 7 days of today's date. Otherwise, I'll consider the evaluation not contested by either counsel for Ms. Smith.
Just real quick, Kalisha Smith, I don't know, my eyes are really bad. From Peakview, I think Peakview is one of the treatment centers they go to. And then at the top, where it says Shania Cassius, Bridges, that's Bridges that they talk about. So, we can see firsthand how some of these places are doing. We'll see what these people did.
For now, we'll continue the matter to November 4th for arraignment as well as for bond reduction hearing. If I do receive an objection from Ms. Barnacle, we'll set the matter for further proceedings.
Thank you.
Thank you. Ms. Barnacle, Ms. Coble, anything further this morning?
No, Your Honor. Thank you.
Okay. Ms. Lansbaum, anything else?
No, thank you.
Okay. All right. Thank you, folks. Thank you, Ms. Smith. Take care.
And then I'm ready on Mr. Bernal.
Good. Morning, Mr. Bernal.
Morning.
This is 20 CR 4030, People versus Bernal. I'll take entries starting with the people.
Eleanor Lansbaum for the people.
And Carrie Coble on behalf of Mr. Bernal, who appears in person on bond.
Thank you. This matter comes on for sentencing. Ms. Coble, are you ready to proceed?
No, Your Honor. I am asking to continue this sentencing. Mr. Bernal does have the new case. There was some delay in that getting open to me because Mr. Bernal had bonded out. That has been open to me now, and I did get an offer on that. That offer is community corrections. However, I haven't had a chance to look at Discovery yet, so Mr. Bernal needs more time to look at that. I will note also he is set for trial in Denver at the end of October, and they are looking at giving him DOC. So I don't know it quite makes sense to proceed to sentencing if we're asking for ComCore here, if he's just gonna get DOC there in the event that he loses. So I understand that this has been going on for a while, but that is my request.
Okay, and what is the procedural posture of the other matter?
It is set for an appearance on bond downstairs this morning in Division 2.
Listen, I want to try something. And if it annoys you, just tell me, okay?
It's not, my understanding is it's not eligible for preliminary hearing anymore since he's out of custody. So my request was actually going to just ask to set it for an arraignment on the same date that we set this, given that I don't think we need a dispo in county court.
Thank you. Ms. Lansbaum?
Your Honor, I am objecting to continuing sentencing on this case. This has been an open probation complaint since September of this year. I understand that he might get DOC in Denver. That's a possibility, but that possibility has been something that the parties have been aware of essentially since this probation complaint was filed. There was a prior private counsel who was here representing Mr. Bernal before Mr. Bernal had the public defender. He had asked me several times if we would agree to be concurrent with Denver. We have all been aware of this Denver case. This isn't a surprise. And the only thing that's happening here is this case is being dragged out even longer. The ComCore screen has been done. I am asking for ComCore in this case. And so I am asking to go forward with sentencing today.
Thank you. I consider the arguments of both parties as to the request for continuance. As Ms. Lansbaum noted, it looks like the complaint here was filed September 30th of 2024, so exactly 1 year ago. This matter has been pending for some time, not all entirely at the behest of Mr. Bernal, but I know that there was a hearing previously set that was then continued. Given the length of time and the fact that the complaint here did not depend upon the Penny Denver matter or the New Adams County matter, I don't find good cause to continue the sentencing. We'll move forward with sentencing this morning. Certainly, if we want to bind up the other matter for consideration, depending on the court sentence here, I'm happy to take that on an expedited basis if that's requested by Ms. Coble in county court. But I will deny the request to continue the sentencing. We'll move forward this morning. Ms. Coble, do you want to pass it to speak with Mr. Bernal a little further for me?
Yes, I would ask to pass it then.
Okay, that's fine. Just let me know when you're ready.
Okay.
Thank you. Ms. Cantrell?
I'm ready to call Julian Menchaca.
Thank you. All right. Morning, Mr. Menchaca. I'm doing well, thanks. This is 23 CR 1086, People versus Menchaca. I'll take entries starting with the people.
Trent Freeman for the people.
Tempest Cantrell on Mr. Menchaca's behalf, covering for Kristen Blodgett. And Mr. Menchaca is out of custody to my left.
Thank you. This matter comes on for a setting. Ms. Cantrell, how would you like to proceed?
Yes, Judge, I'm asking to continue this matter to trail Jefferson County 25 CR 1084. It is next set on October 20th, so I'm asking to set after that date.
Thank you. Mr. Freeman?
Yes, Your Honor, if I could have 1 second.
Sure.
And this is Ms. Blodgett's case, so it'll be a Monday or Wednesday.
First, I have no objection to the set over, but I want to make sure there's a chance we may withdraw the complaint in this matter, and I want to inform the court if we're doing so before we set the case over.
Okay.
Let's take a field trip. Real quick. I'm gonna have to. So, in Colorado, I don't know if they do it everywhere else. Okay, I just know in Colorado, they grade their judges. Oops. They give their judges these scorecards. Oh, Kathleen. And how they do it is, there, you can see that now. So, we're looking at we're looking at Brett's 2024 scorecard, all right? So they sent these surveys to 678 attorneys, 21 responded. Court attorneys, 58, 0 responded. And then non-attorneys and court staff, they sent 2,497 surveys to the court staff. I'm so sorry. One person responded. So this is the survey that they sent out. His overall score is a 3.1. If you remember, Judge Eric Johnson was way lower. I got really mad when I saw Judge Eric Johnson's scorecard. So 90% of attorneys thinks that he meets standards. 53% of non-attorneys thinks that he meets standards. Case management, how fast he gets these cases out, 3.2. That's what made me pull up this scorecard, because that last case we were just looking at was a year old. That's forever long. He pushes cases through fast. It's one of his best scores. Application of and knowledge of the law is 2.8. Come on, Brett knows his stuff. We see him. Communications, I think he's a great communicator. Diligence, I don't know what that means for a judge. Judges don't actually, they rule on what is put before them. They don't go and get stuff so I don't know what diligence, I don't know what that means for a judge. It doesn't make sense. Demeanor, he could have scored higher. He's great. And fairness, look how low that is. I wonder if that means he's harsh, or if it's the prosecutors that called him unfair. So overall he gets a 3.2. Attorneys, they give him a 3.6. I think their weight means more to the higher ups than the non-attorneys, which is a 2.8. But I'm just wondering what that diligence means. Okay, let's look. Communications, good. Demeanor, good. Diligence. Overall is 3.2. Attorneys think he's very diligent. Non-attorneys, not so much. So, uses good judgment. Overall, 3.4. Oh, look, no non-attorneys for the first three. He does. Is willing to handle cases on the docket even when they are complicated and time-consuming. He does that all the time, and he does a ton of trials. So that's a high freaking score, and he deserves it. Does necessary homework. Okay, so diligence is when over the weekend, he goes through the cases for the week to make sure that he remembers everything. That would make sense. Begins court on time, 3.1. That means sometimes he doesn't. What? Maintains appropriate control over proceedings. Now that I know that this little survey result is here, I should go look for the lowest ones of the judges. Because then that's when we'll see the most craziness in their court. 2.9 is pretty low, though. Sets reasonable schedule for cases, 2.8. Why? Oh, these are all non-attorney scores. is prepared for cases 2.7. Manages court proceedings so there's little wasted time. They're wrong. They're wrong. He does do that. 3 appellate judges agreed that he's a 4.0. The appellate judges gave him a 4.0. I'm not reading all that. Alright. We need to get back to work. I don't even know why you guys made me go down that rabbit hole. Don't worry, I'm gonna fix it like it was. There is sound.
So, yes,
There
Your
you
Honor,
go.
I think at this time we are going to ask the court, well, inform the court that we are going to withdraw the complaint. We have no objection to setting over to trail the Jefferson County matter.
I'm sorry, Mr. Freeman, I think I misunderstood. Are you moving to withdraw the complaint or you're not moving to withdraw the complaint?
We are moving to withdraw the complaint, Your Honor.
Okay.
So we don't need a new court date?
Yeah, in which case I don't think we need further settings. Okay. Ms. Cantrell, I assume no objection.
No objection.
Okay, thank you. People are moving to withdraw the complaint filed on August 5th. In light of that, Mr. Menchaca will simply remain on the original term. It looks like it was a 4-year probation sentence from July of 2024, so term will run through July of 2028. I'll release any bond or summons. Ms. Cantrell, anything further?
No, Your Honor.
Okay, Mr. Freeman, anything further, sir?
Just checking out. Nothing further from the people at this time.
Okay, and just double check, Mr. Freeman, are we very compliant as to that? Does look like it was a victim opt-in.
We are very compliant.
Okay, all right, thanks, sir. Okay, so Mr. Menchaca, the matter will be closed again, so you're just on the same term of probation.
Thank you.
Okay, thanks, sir. Good, Mr. Ray?
Good morning, Your Honor. David Quick, please.
Thank you. Okay, this is 25 CR 989, People versus Quick. Good morning, Mr. Quick. Take entries, starting with the people.
Good morning, Judge Megan Salibi for Christina Blumen for the People.
Good morning, Ms. Libby.
Good morning, and we are in VRA compliance. They are present virtually.
Thank you.
Russell Ray here on behalf of Mr. Quick, who's present at the podium with me on bond.
Thank you. This matter comes on for initial arraignments. Mr. Ray, how would you like to proceed?
Judge, I think both parties are moving to continue this arraignment, reset it, or continuing to negotiate.
That's
Thank-
correct, Judge.
Okay, thank you. Given that this is the first arraignment, I do find good cause to continue the matter. Mr. Ray, Ms. Sleepy, how far does it make sense to look?
I'll defer to Mr. Ray.
Standard 4 to 6 weeks.
Okay, thank you. We'll continue the matter for further arraignment in 4 to 6 weeks.
How's Tuesday, November 18th at 8:30?
That's perfect for my schedule.
Just one moment. I'm looking at Ms. Blumen's
Sure.
calendar. It looks like she's out that week.
Natalie Scarpello is also on this case.
Judge, I'll go ahead and accept it.
Okay, thank you.
There is co-counsel, and if necessary, I can cover it or have someone from SVU cover.
Okay, thank you, Ms. Salibi and Mr. Ray. Matter will be continued to Tuesday, November 18th at 8:30. Bond will continue as well. Anything else from either party?
No, thank you, Judge.
And anything else from the people?
No, thank you, Judge.
All right, thank you, folks.
Thank you, Your Honor.
Thank you.
I would like to see how he handles a
Your Honor, I
soft
think
set,
we're ready on the
and a Karen.
Legas.
Okay. Thank you. We're recalling 24 CR 708. Mr. Paulson is present for the people. Mr. Legas is present out of custody pro se. Mr. Legas, have you had enough time to decide how you want to move forward, sir?
Yes, Your Honor.
Okay, and how are you asking to move forward?
We're asking for a continuance.
Okay, Mr. Paulson?
That's right, Your Honor. Mr. Legas has a number of pending revocations in different jurisdictions. It sounds like there's a tentative agreement with him and Arapahoe County. I need to communicate with them before I decide what I want to do. So I would ask, and I think the defendant is available on this date, that we set it on October 22nd. And I will communicate with Arapahoe County and other jurisdictions about how they're planning on addressing his revocations and the proposed offers there.
Okay, and Mr. Legas, is that what you want to do, continue to October 22nd?
Yes, Your Honor.
Okay, all right, thank you. I do find good cause to continue the matter for setting to October 22nd at 8:30. Anything else from either party?
Not from the people.
Okay, do you have any other questions for me, Mr. Legas, or anything else, sir?
October 22nd at 8:30?
Yes, sir.
Okay, that's
She's
it.
so mean. I wanted to see what she had. I think she had a little carton of milk, guys. A little carton of milk you got in school. And now I'll never know because she turned her freaking camera right when I was looking.
Okay, we'll see you back then.
Rude.
All right, thank you, Your Honor.
Some people are rude. Attorneys are rude. Show me your milk. Now I'm gonna go drink some milk today because it's delicious.
Just do some checking out. This is hard.
Come on, Brett.
Mr. Brockett?
Yes,
There we
I'm
go.
ready on Mr. Ironhope, if we can give Mr. Paulson just a couple seconds here to finish that.
All right, thank you.
Request denied. Let's go. Move it along. He's gonna get a bad score. I feel like getting a remote job at the Colorado courthouse just so that I get that survey.
Okay. Morning, Mr. Ironrope. This is 16 CR 2325. I'll take entries starting with the people.
Danny Paulson for the people.
Aaron Brockett on behalf of Mr. Ironrope.
Thank you. This matter comes on for setting. Mr. Brockett, how would you like to proceed?
Yes, Your Honor, we did just pass up a probation violation advisement.
Thank you. Mr. Ironrope, I'm going to go through this paperwork with you. If at any point you have any questions, feel free to stop me and you can ask me or Mr. Brockett, okay? So I have what's called an advisement for violation of probation. Did you have time to go through this with your attorney?
Yes, sir.
Do you want any more time with Mr. Brockett to talk about the paperwork or what you're doing today in general? Okay. There's a signature here on the defendant line. Is that your signature?
Yes, sir.
And there's initials on the line that says, I admit the allegations of the complaint. Is that what you want to do this morning?
Yes, sir.
Do you understand that you do have the right to a hearing on the issue of whether or not you violated probation?
Yes, sir, I understand.
Okay. And do you understand that if you admit you violated probation, you'll be waiving that right to a hearing?
Yes.
Do you also understand that if you admit you violated probation, your probation will be revoked and you can be resentenced anywhere up to the maximum for the class 1 misdemeanor that you were on probation for?
Yes, sir.
Do you have any questions for me or Mr. Brockett at this point?
No.
Is anyone forcing you or putting pressure on you to make this admission?
No.
Are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening this morning?
No.
Thank you. Understanding those rights, do you still want to admit that you violated probation?
Yes.
Thank you. I'll accept the admission. I find it to be knowing, intelligent, and voluntarily made. Mr. Brockett, asking to move forward to the resentencing this morning?
Yes, please.
Okay. And any objection there, Mr. Paulson?
No.
Okay. Go ahead, sir.
Your Honor, I understand there's frustration with this case, and I think that's reasonable that the restitution didn't get paid. But this is a misdemeanor. It's from 2016. Mr. Ironrope has essentially been on probation for 5 years.
Mr. Ironrope is in trouble, guys. He hasn't paid his restitution, and it's almost 10 years old.
It was extended to pay that restitution. He doesn't intend to pay it, but he just hasn't had the means. He had some pretty big life events His family's house burned down and they had to find a new residence. He also found out that he had epilepsy and was having seizures, lost his employment. He does have 3 kids. And so
He lost his employment for all 10 years? Is that what happened? He's been looking for a job for 10 years? Judge, I put in 3 applications a day, every day for 10 years, and I just can't find a job in this economy.
this can be a civil judgment. He will pay it. I think he's going to try and make a small payment today. He also served 41 days in jail on this case over the pendency, and I don't think a further sanction makes sense here.
When?
While he didn't stay in touch.
When did he spend time in jail for this? Because if it was this month, which there's only 4 days gone in this month, so it wasn't, I would understand. But let's say it was 2 years ago. Like, he spent time in jail for this. That he understands the importance that the court isn't playing around. Or maybe they are playing around and he's going to get more time. We'll see.
With probation after it was extended. It really was just extended because of money, and I think given his house and new medical diagnosis and other responsibilities, he just simply didn't have the ability to pay. I also think the amount of time he's been on probation and the amount of fees and fines and specifically supervision fees that he's accumulated really goes against probation being paid, is that amount is almost is approaching the restitution amount. So at this point, I am just asking.
If I was getting nailed every month with this huge bill, because probation is very expensive, it just is, I would do what I had to do to stop that bill. I would pay something towards restitution. Pay as much as I could towards restitution. You can't tell me that he has had 10 years. How much is his restitution? $711,000. It has to be that or higher for you not to have done something in 10 years.
Asking to terminate the case. I don't really think we can extend it, as he's almost at the 5-year mark on a misdemeanor anyways. So that would be our request.
Thank you. Mr. Paulson?
I'm in agreement. I disappointed that we didn't get any restitution, but I think that revoking, terminating, and converting everything to a civil judgment is the best course here. We're close to statute of limitations. Extending probation for restitution only at this point is a very dicey proposition. That wasn't so back when it was extended, but at this point, I think there's some case law that suggests that someone like Mr. Ironrope, you couldn't extend it at all if without proof that he's not indigent. And so I think that just terminating at this point is the appropriate outcome.
Thanks, sir. Mr. Ironrope, anything you'd like to let me know, sir? Okay, thank you. Thank you. I've considered the arguments of both parties, reviewed the special report and the affidavit, noting the record from the parties, as well as the underlying nature of the offense. I do find the recommendation to be appropriate, notwithstanding the fact that no restitution has been recouped at this point. So I will terminate probation unsuccessfully. I will sentence Mr. Ironrope to a period of 41 days in the Adams County Jail as a sanction and grant 41 days of pre-sentence confinement credit. So this matter will be closed. Outstanding restitution and court costs will be reduced to a civil judgment. So certainly, Mr. Ironrope, you're still going to be responsible for that. So I do hope that you make whatever payments you can, but this matter will be closed. Mr. Brock, anything further?
No, Your Honor, thank you.
Thank you. Mr. Paulson, anything else?
No.
Okay, thank you, folks.
Bad news, good news. This is a bad news, good news situation. Bad news, is it's civil now. It's harder to get money from civil. Good news is it's civil now. So if they push it, if they take him to court, and if they push it, he will get criminal charges for not paying. He will go to jail for not paying. I don't see Sandra. Oh, there. Hi, Sandra. How did I miss you sneak in? Hi, Walter. I must have missed chat for the last few minutes because I was watching court videos. It's a trap I fall into sometimes, but barely ever. Normally I watch chat. Sometimes he's so cute, guys. Look at him. Isn't he like a little 10-year-old little boy? I don't know. You see chocolate on his face and on his hands. Alright. It is time for OJ. Wait. Before we leave. I asked you all to do something fun yesterday. Did anybody go watch a show? Did anybody go out and do something fun yesterday? Anything fun? You know what? Post it in Discord. Or on the comments. If you're a replay crew, put it in the comments. I want to hear what you guys did yesterday. That was fun. That was for you. That you're going to remember that you enjoyed yourself. And if you didn't do anything, shame on you. I wasn't asking, I was telling. Go do something fun for you today. So anything. Went to the library. That's fun. Go do something fun today if you didn't yesterday. You can do free stuff or you can spend money. It's up to you. Bye, guys. Have a good day. See you in OJ.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in